Hello. Hi. Good morning and thank you very much. As introduction bit, thanks to Ankita, thanks for introducing us. And for legal side, very important factor in the growth of shipping. We have been all factors in different parts of the world. And thanks to them to be in this platform. And Magdalene, I have known her for some time. Sochannam again, I have been, we have not worked together, but he has his own firm and he is a practicing maritime lawyer. Jimi, again, very old friend, senior to me, been in the industry, now presently practicing from Goa. Ravi and me go back very long time because we have worked together also. I will let them introduce themselves briefly and their firm where they are today. It's nice to see that we are in a place today to speak where we are all working together in this industry and we have seen a bit of this. And thereafter we'll make it a bit interesting for all of them as to how each jurisdiction deals with the resolution bit and the avoidance bit. But Magdalene, with you starting as to, would you like to?
Hello. Morning, everyone. Sanjam, thank you for the invitation and good morning to my fellow panelists. My name is Magdalene and I'm a maritime lawyer from Singapore. I am a co-founder of a Singapore law firm called AsiaLegal LLC. I'm also a qualified arbitrator and a qualified mediator. I also sit on the Singapore Chamber of Maritime Arbitration panel and also on the admissions committee. And I'm also known Sanjam forever because I was ex-president of Vista Singapore.
Hello, my name is Kaushik Sochannam. I'm the managing partner of Sochannam Legal. It's a maritime and trade practice based out of Mumbai. We look at both dry and wet matters of shipping, and we work across the country. Thank you.
I think it's almost afternoon, so good day, everybody. My name is Jimi John. I am a maritime lawyer as well as a general lawyer because now I'm based out of Goa, and we can't have a niche practice of only any particular area in Goa. So I do undertake all types of commercial contract cases. I'm also a qualified arbitrator and a mediator, court-certified mediator as well. And presently I am the president of Vista India. That's how I'm in touch with Sanjam. And that's about it from me. So over to Ravi.
Yep, thanks. Hi, good morning, good afternoon, mix of both. My name is Ravi Jawani. I'm from Dubai. I and Shiv have been working with each other for a very long time. It's been about 2.5 decades. Sanjam, thank you very much for the lovely invite. I belong to a firm called Fitche & Co. We specialize in shipping. The firm's primary focus has been to deal with maritime matters. We are one of the prominent maritime law firms of the UAE and very happy to share our thoughts and advices in this forum. Thank you once again, Sanjam.
Thank you guys, thank you very much. And it's good to know that we have 3 core forums where a lot of Indians have commercial business and other side. And we constantly have interaction in different areas and interconnected way of working there. Magdalene, and to everyone, what would you guys personally, in the sense for a dispute avoidance with your client perspective, what are the suggestions that you usually give with respect to each of the jurisdictions in the sense because you have different problems at different jurisdictions? I would like each of you to share your bits so that everyone is aware as to how things are managed or advised by you, client perspective, as well as the trends with respect to the courts or the tribunals which are going on presently.
Okay, I think dispute avoidance starts with your contract and careful drafting of the contract. Of course, there are the obvious things to look out for. For example, know your contracting party. I've recently am currently doing a dispute, for example, where the client used the BIMCO form, which provides for arbitration, Singapore law and arbitration, but he very cleverly put in the box Singapore court, thinking that it will cost less, which sometimes can be the case in Singapore, and be more convenient. But what he doesn't understand, and this is where you need to think more carefully about this thing, is because his counterparties in China, the enforcement of an arbitral award is much easier in China than the enforcement of a Singapore court judgment. So it starts from little things like that as a non-lawyer you may not know, but it's knowing your counterparty and then applying that towards thinking potentially how I would have to resolve disputes with this counterparty or enforce such disputes. So that's one area.
Right, thank you. Thank you very much.
Dispute avoidance and dispute resolution mean different things for lawyers and clients. If you were to ask a client what they mean by dispute resolution or dispute avoidance, 9 times out of 10, they would tell you this much: give me a resolution without resorting to arbitration and litigation. They are driven by this ideal primarily 3 reasons: to ensure a continuing business relationship with a counterparty. Disputes break that relationship and they do not want that. Number 2, to avoid the uncertainties of litigation, arbitration and recovery. And number 3 is not to spend on external legal counsel. It's bad news for all of us sitting on this panel. But having said that, from my experience, when I see a client overemphasize on dispute avoidance, at a time when a dispute arises, the client commits certain critical errors. And I will just highlight 3 of them and my co-panelists can take over. They are: number 1, the client knowingly or unknowingly concedes critical positions with a hope to achieve a resolution. Number 2, they do not effectively communicate their position in a non-accusatorial manner. At the end of the day, if you desire your counterparty to agree to a particular position, you should be in a position to effectively communicate it. Otherwise, the entire process is a futile exercise. And number 3, to engage external legal when the file has been mutilated beyond recognition. These are the fundamental aspects when I look at dispute avoidance or dispute resolution from a client perspective, and where I see certain lacunas in their approach.
Right. Thank you. Thank you very much. Jimi, specifically with respect to, as you are now practicing or doing a lot of arbitration,
Yes.
what is your way of looking at things when you want to try a party who is before you? How do you promote it to get into consensus or resolving their,
Thank you, Shiv.
avoiding entering into a...
Yeah. So I believe as long as there's life, there cannot be 100% dispute avoidance. But of course, disputes can be curtailed to a certain extent. And like how Magdalene and Kaushik has mentioned, contract drafting is the basis for everything. So one could have something like a notice and escalation clause, wherein if there is even a whisper of a dispute, the parties can go into negotiations and mediations. In fact, the statutory enactments also are pro-mediation and negotiation and opposed to litigation and arbitration. So for example, we have the Commercial Codes Act, where the mediation is a prerequisite before you file anything in the commercial codes. So the trend is basically to avoid litigation and arbitration, like how Kaushik said, bad news for us. But yeah, in order to avoid the overload of cases, that is bombarding the courts these days, especially the Indian courts, one should, I believe, engage in alternative mechanisms and include such clauses in the draft so that it doesn't reach the state of arbitration or litigation.
Right.
I don't think I, as a lawyer, should say that, but yeah, why not?
Thank you, Jimmy. Ravi, from your side, how do you usually, because UAE is a very versatile jurisdiction in a lot of ways, how do you deal with these issues when you're advising to the clients, whether it is X, where your clients intend to take disputes to, or they don't want to take a dispute with the ship? Exactly. This is the.
So the way how it works is this. Everybody loves to have wonderful contracts. The contracts are available on ChatGPT, on Google, is fine. The reference what has been made is with regards to, in shipping parlance, the reference gets made that refer to GenCon for rest of the terms.
Right.
Where GenCon is a very standard, universally known contract. The difficulty happens in the element of recap, when the recap happens through the certain medias like WhatsApp exchanges. So the earlier trend, what we used to have in shipping for the fixture notes, has now become much more smaller on WhatsApp exchanges. And that creates a huge amount of disconnection between what has been said and what is received and what is perceived. More so, the Gen Z element of using the emojis are creating a huge amount of disruption in understanding that today are we using words anymore, or we are using thumbs up, using heart emojis in an actual contract which is going forward, but rest of the terms the GenCon has to look forward. So the difficulty what happens in UAE is that, unlike the countries representative who are on this panel, UAE is a civil law country. So the precedence does not apply.
Correct.
Unlike in India, UK, Singapore, where you have the law of precedence, if you have a Supreme Court judgment, everybody follows. UAE, that is not the case. Every case is dealt on its own merits. So it becomes very hard when a client comes to ask that, oh, I'm fallen in trouble because I meant something else has come into picture, or something else has been perceived. How do we now get out of it?
Correct.
And there is no clear answer to this. So all we tell the clients over and over again, that you may have the Gen Z elements with regards to whatever it is, still go a bit traditional way of putting on email exactly. Open up what you really mean.
Right.
Like if you recollect, the simple shipping terms like MOLO, more or less owner's option, CHLOO, more or less the charter's option, right?
Correct.
5% MOLO, 5% this. But those are accepted abbreviations. The emojis and are not accepted as of now. Yes. So those are the elements. It becomes very hard then to approach the court, and the court says that, oh, is this a love fight? Because he sees the color copy of the heart, and it's not a love fight, it's a contractual dispute what has happened.
True.
So that's the problem what happens in that part of the world. So what we always ensure that if you do not want to have UAE as a jurisdiction, you want to have UK or India or Singapore, it's fine. Why? Because there the in-depth interpretation could be seen because there are precedences in place.
Correct.
But unfortunately in UAE, that's a problem what everybody faces. And when you have to get that translated into Arabic, becomes a bit more of an issue with regards to explaining to the court as to the intention of the party. The other thing which I'll quickly touch upon is, and I'll take not more than 5 seconds, all other countries like the common law countries, the lawyers enjoy the role of arguing in the court. UAE and Middle East countries, civil law countries, it is advocacy by paper. Lawyers do not get an opportunity to explain. So how much emotions are you going to bring on paper when the evidence speaks something else? So that's a bit of an issue. Emojis, especially yes, when you have that. So these are the live elements which are happened, which have created a lot of trauma in the industry as to what exactly is anticipated and perceived.
No, I understand, because usually the clients who also, these are the problems which we also face. But similarly for India also, we have our own issues because we have federal, we have our high courts passing different country judgments to each other. We have this constant, but yes, certainty wise, there are a lot of precedents we can rely on, etc. But Singapore is beautifully groomed.
In fact, I just wanted to mention about, when you mentioned about emojis, India does not have a definite framework for emojis, yes, but the WhatsApp messages, they are considered as virtual verbal communication. So they are sort of categorized and accepted form, provided they are authenticated by metadata certification. So we have that aspect, but not emojis as yet.
So mediation, like we said, like Jimi correctly pointed out, is a very good thing which is brought in under the Commercial Codes Act by India. to avoid any unnecessary disputes. Some courts are very serious about it and they are taking steps to ensure that people don't go under frivolous litigations, etc. And especially for a jurisdiction like India, I think it's a rightful thing what has been come through. I think Singapore, if you would like to explain how...
Thanks. In Singapore, there is a very strong and clear trend towards mediation as the first stop when you have a dispute before you go to litigation or arbitration. In fact, last year the new rules of court were introduced, and it very specifically says now that you have a duty as a lawyer to advise your clients to try to settle, and you have to demonstrate in the initial filing that you have to state whether you have tried settlement, and if you haven't, why. And this is now embedded in the new rules of court. So these are the court procedures before you even start your writ of summons. Also, there is the Singapore Convention, UN Convention on Mediation. And I won't go into too much detail, but the idea is akin. The idea is that the Singapore Convention on Mediation will be like the New York Convention when it comes to enforcement of mediation settlement agreements, the same way that you are able to enforce arbitral awards in various jurisdictions. So if your jurisdiction and your country is a signatory to the Singapore Convention, then you'll pass also into force in your jurisdiction, and it will become that much easier to enforce that mediation agreement. So the trend is very strong. On the practical level, I'm not sure how many here are clients and how many here are lawyers, but a few years back, the Singapore Mediation Center grabbed a whole bunch of shipping maritime lawyers and put them through a mediation course. The goal is twofold from what I understand. Number one, to show you that it is not detrimental to your practice. The rise of mediation is not detrimental to your practice. You can still, a happy client is a happy lawyer, and he'll come back again because you solved his problem for him.
True. No, that's a very encouraging thing in a way that I've seen Singapore growing from a brilliant arbitration and a mediation center, and they focus a lot on mediation. And I think we are also following, India also is following quite a bit of those steps to ensure that we do mediation at the first limb, try to avoid disputes. Would you like to add your bits about...
I mean, in the Indian context, those statutes says for commercial suits, you give an attempt at mediation. In the reality of the way it works, I really don't see many clients taking a proactive step in initiating mediation and seeing through that process. So there is a gap between what is contemplated and how the market is reacting. And even when you have statutory bodies providing for mediation as a method to resolve disputes, I don't see a genuine effort taking place between both the parties to see through that process. Rather, it is a pro forma effort to say that we tried, we spoke, and I don't think we're going to be able to bridge this gap. So I see a gap between what the law contemplates and how it is implemented, and also taken seriously by the litigants.
I agree for the clients, but I believe it's partially our mistakes as lawyers that we should encourage parties also to see through the merits and demerits of the case and not only think about our commercial reasons, and kind of advise them as to how to focus to resolve it. I think Singapore has been achieving that. Also, Singapore reason is because if you go to arbitrate, then the client is, I think the pockets will tear and then you can't, it's too deep inside.
Yeah, you need big pockets. But I'll just give you one personal example,
Yes.
if you don't mind. Now, you wouldn't think a collision claim or collision dispute could be mediated.
Right.
But I actually have I've been lead counsel in a collision trial a few years back, and we went for mediation before the trial, just before the trial, before ex-master mariner become a lawyer. So he understood the rules of the sea plus the rules of the law. Unfortunately, we didn't settle before trial, but then what happened was, after the trial, and the judge found it was 50-50, both sides, of course, appealed because it's 50-50. You have a 50-50 chance. We went for mediation again before the hearing of the Court of Appeal, and we settled. So even after your trial, even after your judgment, it's still open for you to, explore mediation.
Thank you. Thank you very much. Would like
If
to
I may add, if mediation is to be taken proactively, at least by Indian entities, one amendment which could be brought into legislation, or rather courts take a proactive steps in awarding full legal costs in favor of the succeeding party. Because right now what happens is courts and tribunals are very reluctant to award legal costs. They somehow look at it as a very guilty exercise.
I agree.
And if we have a situation where courts and arbitral tribunals are willing to say the succeeding party will be entitled to full legal costs, then I feel there will be more of an incentive for mediation by the parties to be taken seriously, because nobody wants to pay full legal costs. Right now we get courts will award costs after 10 Supreme Court hearings, maybe around $10,000, and each senior counsel is charging $10,000 to $15,000 per hearing. So it is peanuts. An appeal bench will award 2 lakhs costs, and legal fees of senior counsel will be around $50,000-$60,000. That is excluding solicitors' fees and junior counsel fees. So I think where tribunals and courts take an aggressive stand in awarding costs, you will see clients being more open to it, rather than litigating on a hunch or on a chance, or litigate to try to achieve a settlement at a later date.
Now, I think cost-wise, these things keep coming up, and I agree that it is important that a bit of deterrent has to be put on a party to...
if I may
please,
add,
please, please.
all right. We do not have anything, any enactment like how we have in Singapore mandating the lawyers to suggest mediation, but post the Mediation Act,
Correct.
the courts are mandated
Yes.
to refer the disputes to mediation in case they feel that there is any iota of a resolution or
Correct,
of mediation.
correct.
So they are mandated to refer the matters to, of course, court-certified mediators, and those proceedings are taken care of.
Correct.
So the parties do not have to...
And the cost of that mediation is very less,
Exactly,
extremely
exactly.
less.
So the courts basically are pro-mediation, so they are making efforts, but like how you said, and how you also mentioned, the lawyers are at fault because we see that, of course, it's ours is per day hearing, or it's like per hour, our billings, right? So you do see the trend in lawyers as to not to, advise clients towards mediation. Yes, of course, unless if they have reached about maybe 5-6 years and they are like, okay, they have, earned enough, they say like, okay, let's try and get into mediation. But yeah, we as lawyers have to make an effort to consider this option as well in order to restrict the disputes that is happening in the courts.
I mean, if I may add, apart from what lawyers may or may not recommend, the psyche of most corporate entities in India is they are not averse to litigation. In the sense they understand how it works, of the time factor, so they don't mind playing the waiting game. More than the lawyers advising to go for mediation or a matter of fees, clients themselves understand that let's wait it out and fight it and see what happens. So I think it goes both ways.
Yeah, you'd be surprised to know that there are more corporates who want to go into mediation now as opposed to litigation.
But that is strategy. How to use it, people are using it as a strategy. For one side it may be beneficial, for the other may not be. But on a long run, if like people want to invest, people want to see results. That's how we see as to faster way to dispute resolution, faster way of how the awards can be enforced, how we can move forward. I think that's the way we should be, and we should encourage our judiciary and other things is what my view is. Ravi, would you like to give a overview on the UAE side, how they are?
Oh yes, UAE is much better in this terms of this. To start with, the case is finished. The first instance, there are 3 instances. First instance, appeal and Supreme Court. Right from the inception of the case to Supreme Court, you're looking at maximum 15 months. And that's maximum. Probably within 1 year, you would have covered all 3 stages. First instance goes in 6 months, full-fledged, very fast. The judges have a mandate to end the case. Experts get appointed immediately. Yes, the element of mediation, what the courts do, in order not to waste time, what they do is, the moment the case gets filed, the matter actually gets registered with the settlement committee, which is the mediation.
Right.
If none of the parties turn up, if the settlement is not reached, in that first hearing, matter straight goes to court, no wastage of time.
Okay.
That's the reason why it is super fast. UAE has, over the period of time, has done a brilliant job in ensuring that the judicial system, you have to understand UAE has got a huge amount of investments that keep pouring in. There's a global investments coming in. UAE likes to be the tallest, the biggest, and they have ensured that the best of the people, the best of the shipping industry people have their presence in our part of the world. And the best way to do that is to ensure your judicial system is kept on top notch so that people feel comfortable in coming there. And that's what UAE has done. Being a civil law country, they also have a common law perspective as well. So there is a very fine balance maintained over there.
Right. Thank you, Ravi. Let's shift a bit from the mediation bit. Let's see the dispute resolution in a different angle, which is the arbitration and the courts. What happens in each of the jurisdictions with respect to the arbitration? I'm sure Singapore has contributed a bit. India, I think, has been pushing. There are quite good commercial men now. There also, I've had instances where arbitrations kind of finish within 8 months, and they are consciously, some of them are actually trying to finish it off. Some get delayed, I'm not saying. It's equal. If each of you can contribute a bit as to how the each jurisdictions have grown up, improved, and the mechanism presently, it will help all of us.
Okay, Singapore is very pro-arbitration. Singapore as a venue of arbitration has been included in the BIMCO standard formats for quite a few years already. So London, Singapore, New York, and Hong Kong. So therefore, we see a lot of arbitration disputes in shipping contracts in Singapore. The courts take a very non-interference approach. So there is no right of appeal. It's only the New York Convention grounds to set aside, meaning breach of natural justice or the incapacity of one of the parties or something not right in the constitution of the tribunal. So very limited grounds. The courts, of course, see a lot of attempts to set aside awards on natural justice breaches, because as a backdoor way to appeal the award. But majority of these setting aside applications do not succeed, unless it's very clear that some injustice has been done. In Singapore, we have SCMA, Singapore Chamber of Maritime Arbitration, specifically for maritime-related disputes, but not limited to maritime-related disputes. It's a non-institutional arbitration rules, which means that you can just say in your clause, SCMA rules to apply for addition. They don't charge an institutional fee, they don't charge filing fees, they don't have an admin fee, they don't have a fund holding fee. So, I always recommend to my clients choose SCMA rules for that reason.
Right.
Yeah. They also now have introduced recently the expedited procedure for any claims below US $300,000. Yeah, and so it's documents only. 21 days after your case statements are filed, the award is supposed to come out.
Right. It's very good, actually. It's been.
Well, on the arbitration front, first, if you're looking at maritime arbitrations in India, you would find Indian public sector undertakings such as Indian Oil Corporation, ONGC, Steel Authority of India, mandating that arbitration is to be held in India, most probably under Indian Council of Arbitration rules. That would be on the maritime front, because they are the ones who have their long-term stems and contract of affreightments, or on the spot market. If you look at the arbitration, how it is conducted, the Arbitration Act mandates the arbitration to be wrapped up in 2 years, or the parties have to go to the court to seek an extension. So this statutory enactment has helped arbitrators in wrapping up arbitration in 2 years' time. And we have had arbitrations where arbitrators have wrapped it up in 18 months and 20 months because arbitrators do not like parties going to the court and seeking an extension of the mandate, because it reflects poorly on them that they have not been able to manage the schedule. So that's an improvement, and courts are more open to passing interim measures orders pending arbitration, and also interim measures or disclosures of assets pending enforcement of foreign arbitration awards as well. Previously, you had to get your award recognized as a decree of a court and then go into execution. Now courts are more reluctant to go into the issues of securing the award amount pending enforcement of the award.
Correct. It's actually quite good developments through the acts and other stuff which have come in, which allows, including the Admiralty Act, which allows you to secure for enforcement, etc. So India has kind of moved forward with judgments also, where it was very easy to challenge. The only thing what we have is the procedural delay, which also we are working towards it. And Jimi, if you would like to say a few things on.
In fact, India's ambition to be recognized as a credible arbitration hub has ensured that measures such as limited court interference and greater respect for party autonomy are considered. In fact, they are trying to be incorporated into the statutory enactment. In fact, the draft Arbitration Amendment Bill of 2024, it's still under review, but it is planning to adopt these measures.
Right.
You know, limited court intervention. And then, of course, despite the absence of such enactment, the Indian courts have always reinforced the pro-enforcement stance, as well as greater respect for party autonomy. We have the Gayatri Balasamy case, as well as the Glencore International case, you know, which talks about if there is an valid arbitration clause, issues such as jurisdiction and waiver are to be left to the arbitral tribunal as opposed to the courts. Similarly, the limited court interference. Now, enforceability can be challenged only if it violates the public policy.
True.
And the 2015 Amendment Act has very significantly narrowed the interpretation of what public policy means. Basically, it only is violation of fundamental laws of Indian policy, or if it is obtained by fraud. So, in order to ensure the credibility of India as an arbitration hub, so we are taking a pro-arbitration stance, and we do have a lot of agreements, like how Kaushik has mentioned, with respect to ONGC and government contracts, which will include the arbitration clause. And it does include the arbitration clause. And with India leaning towards, pro-arbitration, we are hoping that India becomes the next arbitration hub.
I think there is positive changes in a lot of way. And as I said, even the commercial arbitrators are very sound about these things, and they are trying to push things to ensure that we kind of finish arbitrations quickly, etc. Ravi, would you like to say a few things from your side of the world?
UAE favors arbitration a lot.
Correct.
Now, very obviously, SIAC Singapore Arbitration Center, SCMA, Singapore Arbitration Centers are very prominently known. UAE is also coming up and have already established DISE, that is Dubai International Arbitration Center. And it's surprising to see that how many people are actually referring now DIAC in their shipping contracts. Now, it may not be the traditional shift from the LMAA or SAIC with regards to charter parties, but what you get to see is among the traders who trade, who have nothing to do with the charter parties, who are the sell and purchase contracts, and the charter party is going to come later, a lot of their clauses are now related to Dubai International Arbitration Center.
Very good.
Because Dubai is becoming a trading hub. Especially, the dream of Dubai was always connecting east with the west. And that's exactly what you can see today, that the arbitration centers are doing phenomenally very well. Now, with regards to the court proceedings, the moment there is an arbitration clause, the courts do not want to interfere.
Oh, amazing.
The similar approach like how even Singapore has got, non-interference. The court will just not interfere unless it can be proven that that arbitration has got a flaw in it, there's an ambiguity in it, there is a problem with regards to the clause, then the courts will get into the interpretation. But if the clause is clear, the courts do not want to interfere. In fact, the courts themselves promote. The catch in that part of the world is, there's something called ad hoc, which we all have in our part of the world.
Right.
UAE does not have the element of ad hoc. So when there's an ad hoc, not a non-institutional arbitration, then the courts needs to be approached in order to appoint arbitrators. Now that process, a person who not only reads English but understands English from the courts panel can become a bit of a dicey element.
Okay.
And this is where the local law understanding, the understanding at the time of negotiation matters a lot.
Right.
That how do you place that code? It's a very simple statement you would have seen, and I'm sure everybody would have seen. In normal charter parties, fixture note, how you have GA stroke ARB, London, English laws, full stop. It's understood what is rest.
Correct.
Instead of London, put Singapore, it's understood. Singapore law, if I'm not mistaken, actually says that if the, by default, SCMA or SIEC will take the jurisdiction if the arbitration is in Singapore. But in UAE, that's not the case. So if you have ARB as DXB Dubai, the short forms, or AUH for Abu Dhabi, or SHJ, English laws. Big trouble in that clause because now ad hoc does not exist. So you have to approach the court. So you see, those are the elements. The fine-tuning needs to be understood well in advance.
So takeaway for the clients is basically ensure your clauses are proper and in order, and you agree to the
Reach
law.
out to your lawyers.
Now we come to the court process in each jurisdiction as to how we, for example, the arrest, which is each jurisdiction are favorable, arrest favorable countries we are. At the same time, resolution or securing, how we secure our claims and how we take it forward from there to the end result. I would like to hear from you guys how to each country, how do we deal with it? If you would like with Singapore first.
Okay, Singapore is a popular, although not easy, jurisdiction to arrest ships as security for your pending arbitration. You do not actually have to show that you've commenced the arbitration. You just have to show that, say that you intend to.
Right.
Yeah. And the ship has to be within port limits. The country is so small, the port limits is not quite the same as the territorial limits. So quite often the ships will bunker OPL, so then you have a problem, you cannot arrest. Within port limits, the grounds for arrest are quite standard, quite in line with the arrest convention, although we are not signatory to the arrest convention. You can arrest also for maritime liens. One unique aspect, though, is the duty to provide full and frank disclosure to the court when you are applying ex parte for the arrest warrant, which means that you have to disclose to the court at that point in time not only facts that are in your favor, but facts that are potentially not in your favor when it comes to its relevance to, say, the beneficial ownership of the ship. So if you knew that, you know, maybe beneficial ownership had passed or there was some change or doubt, you have to disclose to the court, even though it's an ex parte application when you apply for the warrant of arrest. This has developed over more than 10 years, this line of cases, and the courts say that you can actually set aside an arrest even though you have jurisdiction but you breach this duty of full and frank disclosure. When I started practice as a baby lawyer, the arrest affidavit in support of the application was 5 pages. It is now, 50 to 150 pages because of this.
Which is very good. Yeah, Kaushik.
In terms of arrest of ships, India follows the Arrest Convention in determining maritime claims and the Lien Convention determining the liens. The court recognizes the power to arrest a vessel pending arbitration, but the lacuna in the Indian jurisdiction is we do not have a statutory enactment recognizing the power of the court to arrest a vessel for an arbitration clause. So the courts have devised a procedure wherein which you can sustain an order of arrest for an arbitration proceeding outside India or within India. So generally it is advisable for parties to make it clear for what purpose they are arresting a vessel, so there is no confusion as to what is the finality of the proceedings for which you have filed them in India. That is one thing. A recent enactment to the Merchant Shipping Act allows the government to directly intervene in the event of a maritime casualty, and all the expenses incurred by the government using all its instruments will be treated as a priority lien just below the crew wages but above the mortgagees. So the government has taken this proactive step in dealing with casualty management and expenses. So they have taken a priority just below the crew wages. So that's a recent development. As regards beneficial ownership, it's a bit of a Pandora's box. Some courts are allowing it, some courts have not. When they allow it, they take the easy way out, saying that the issues as to ownership will be determined at the stage of trial. Right now, we feel a prima facie case has been established, which in my view, especially in beneficial ownership, arrest should not be done, but courts have taken the easy way out. We have not gone to the South African extent of associated ownership arrest. So in terms of arrest of vessels, that is where we are.
Thank you. Jimmy, quickly to shorten this, I think...
just add one more.
No, I'm not shortening What I'm saying is, a bit more to add on to this. So there are parties who are in arbitration, like he said. Parties who are in court for securing their claim may not be qua the arbitration, but qua the suit. So India has a system by which you have to file the complete proceedings in the court,
Right.
even though you have an arbitration clause. Then you come forward and then you file a section 45 and say, okay, I have an arbitration clause, which gives right to either of the parties. What I'm asking you is, isn't it better that we go to the arbitrator and get our claim secured, or is it better to go to an admiralty court and secure and then go to arbitration? Just a quick one.
In fact, under the Admiralty Act 2017, we can arrest the vessel to secure an arbitral award. So I think it would be better to go to the court in order to secure the arbitral award, to secure, to arrest the vessel, and because the procedures is already set.
Right.
So we can ensure that when an award is passed, at least we have an asset to be executed.
Right.
Yeah?
If I may add, I don't think an arbitrator would have the power to detain a vessel. It's more of a judicial process.
No, I'm not on the judicial process. I mean the way of securing, which is under 17, which are... Sorry, Ravi, if you can...
So some time ago, I just said that UAE likes to be the tallest and the biggest, right? So with regards to the arrest, we merged the 1958 and 99 convention, and we have more lists where you can arrest the vessels.
Like we used to have.
Where even 99 convention legislators were shocked that how the hell did you come up with all these names? And we wanted to put, you throw it in, we want to arrest everything in. But having said that, arrest is now very, you can say, lucrative.
Relatively easy.
Very relatively easy, very lucrative for lawyers in UAE. But at the same time, there is an element with regards to the substantive proceedings. Now, unlike, again, in the common law system where you have action in rem, right? UAE does not know that, the concept of action in rem. So the arrest of the vessel is actually considered as a precautionary security.
Okay.
Which means you have to file substantive proceedings thereafter. Now, 2 issues over there, or rather 3 issues. Number 1, parties have agreed to UAE jurisdiction, fair enough, substantive proceedings before UAE. Parties have agreed to arbitration, so you have now the 3rd step of arbitration, be it Singapore, London, Dubai, and then inform the substantive court of UAE, please put the matter on hold. You have to prove that the arbitration has been initiated, which is very easy in Singapore or in London because it's only 1 notice of arbitration by laws. Here comes the 3rd issue where there is a high court or a court jurisdiction outside the country. Because after arrest, you have only 5 days to initiate substantive and to inform the court that I have already initiated outside. Now, if it's a court proceedings, the documents have to come through the diplomatic channels. Because there is no bilateral. UAE has got bilateral treaties mostly with the GCC countries, not with the rest of the world. So that's where the recognition, if you have initiated, let's say for the sake of example, Malaysia, if you initiated a case in Malaysia, for UAE to recognize that the substantive proceedings have been initiated, the Malaysian court proceedings papers have to be translated, routed through the diplomatic channels, which cannot happen in 5 days. So that is the 3rd element, which is an issue.
This is actually interesting. I was also not aware about it. Thanks for informing us about it. As we now have only about 4.5 minutes, if anybody has any interesting questions to raise on these interesting lawyers, not me, please. Yeah, Paul. I think somebody should pass the mic to him.
First of all, thank you, Moderator, and for the excellent panelists for a very interesting discussion. I'll ask a question, but first an observation. It's long been held that mediation will never work unless the judiciary and government are behind it, and that's why it works in Singapore. Lawyers notoriously regard it as eating into their rice bucket, and lawyers need to grow up and understand that it's a fantastic way to bond with your client, to sit through a successful mediation. And lawyers need to understand that if they're going to advise on mediation, they ought to know about it and know that the skills that are adopted by professional mediators are very different from those that lawyers use. Lawyers should not automatically believe that they're great mediators simply because they've been handling disputes. In fact, it requires a completely different skill set. Lawyers can bridge that and are very good at parts of mediation, but parts of mediation, and I'm talking from my own experience, having to rewire myself, you need to be humble and you need to dig into it, and we need to encourage parties. Now, that's my observation. My question is this. There is such a concept of arb med arb, and that seems to me to be a win-win situation, and I'm surprised none of the panelists have actually mentioned it or mentioned offering that to their clients. It's a total win-win. You can't have mediation without agreement, so put it in your arbitration clause and you've got the agreement. But can I just say Singapore's gone one step further. It's actually got SICC, or med SICC, so that's court, med court, but it's an international court. Those are just a few observations. I am passionate about mediation, and I'm very pleased to see that panelists too are passionate about it, and I think we need to advise our clients about mediation properly. Thank you. But can I just have a comment about arb med arb? What the panelists think about that as a concept?
Right.
Thank you.
If you guys would like to answer, because I think, Paul, I agree with you. It's consciously our jobs to get it done.
If I may, India has not developed to that extent to include, or the lawyers have not developed to that extent to include the clause arb med arb, which is a wonderful initiative actually, because we don't have, the Mediation Act has come into force only in 2023.
Correct.
And under that act, the court is mandated to refer everything to mediation, right? So the clauses, the lawyers have not yet been trained in order to think in that aspect, in order to include it in the contractual clauses, as one of the contractual clauses. So hopefully, but the Supreme Court in India, under the aegis of the mediation committee, trains lawyers as mediators, and they become then the court certified mediators, and they are assigned the cases from to the courts. But otherwise, privately, we don't have mediators, or they are not entitled to take, or they are not allowed to take cases.
So the intention of the government is towards the mediation.
Right.
They have taken steps towards that. And I think consciously we are also moving to the fact that we do not want to lead unnecessary arbitrations ahead. We will try and resolve it. And there are consciously moving towards, so including the Arbitration Act when it came, like Kaushik mentioned, there's a deadline which is fixed, and it puts the onus on the arbitrator to finish it in a particular time. So these are the steps which have been taken on the India side of it. Singapore has been far ahead and positive about things in moving and taking steps. And I'm sure UAE has always been...
and the fact that we are just growing as an arbitration hub, mediation is sort of taking a back seat, and it has only been relegated to the courts as of now.
Yes. Yeah. I hope. Anyone else would like to ask? Yes, please. Can someone pass the mic?
Hello, I am a J.S. Rawat advocate. I am an advocate in the Supreme Court. Now, my experience is that the arbitration has become another sort of a litigation in India. Now, so far you said that the mediation in India is since last 20 years back. Now, most of the mediation in India is a court-monitored mediation. Now, I want to know from Singapore panelists that how the institutional mediation is successful in Singapore or not in India, because in mediation in India is lost for than 20 years. So in India, only the court-monitored mediation is conducted, not a private mediation, not an institutional mediations. Now, so far the Mediation Act is concerned, even that Mediation Council has not been constituted by the government, so that even the expert mediator cannot do a private mediations. So I want to know that how institutional mediation is working in Singapore.
Thank you for the question. It's a mindset change, and they have approached it from the mindset of the advocates and advisors, and the mindset of the clients and disputants. So, as I said, they literally grabbed a bunch of maritime disputes lawyers and made them learn about mediation, so that you understand it, you are actually a trained mediator, and you understand that it's a different set of skills and the benefits. From the client's perspective, the persuasion point is, going back to what was said previously, it preserves the relationship. So when you're in a dispute with a counterparty where your relationship is important to you, this is the selling point of mediation. And as my fellow panelist Ravi also said, hopefully it also deals with the emotions behind a dispute, not just the paper, which you can win the trial, but your emotions may not get that airing, which it will get in a mediation setting. So it's a holistic approach, I would say.
Thank you very much, and thank you to my fellow friends, and thank you very much for this insightful panel discussions that we had. I think I learned a lot also from here, and thank you very much to everyone. I'm sorry, time's up. If any questions, you may please pose it to them, not to me. Thanks a lot.